everyone. It's good to see everybody. Thanks for coming. We must have some sort of hearing people want to hear about. We have two bill hearings, and I will just get started right away with House Bill 2648, and we'll have Natalie give us an overview.
Thank you, Mr. Chairman. House Bill 2648 requires a criminal conviction for civil asset forfeiture. It requires remittance of the proceeds to the state general fund, and it removes provisions making motor vehicles with altered VINs contraband. Section 1 amends KSA 8-116 to remove the current law provision providing that every motor vehicle, trailer, or semi-trailer with a vehicle identification number that's destroyed, removed, altered, or defaced that has been seized. Under current law, that is contraband under KSA 22-2512. And so we're removing that current law provision in its entirety. Section 2 amends KSA 22-2512. That is the statute for what happens with property that's seized by law enforcement. This section is amended to provide that if no criminal charges are filed or prosecution is declined in a case, then any property that was seized in conjunction with that shall be returned to the owner or disposed of as further provided in that section. Section 3 amends KSA 604104. That's the statute that provides the list of conduct giving rise to civil asset forfeiture. This section is amended to provide that that conduct only gives rise to forfeiture after a conviction of that related offense. A criminal conviction would not be required if property is forfeited pursuant to a plea agreement or pursuant to an agreement for a grant of immunity or reduced punishment in exchange for testifying or cooperating in law enforcement or criminal prosecution. Section 4 amends KSA 604105, and Section 5 amends KSA 604106 in the same way. Those are the statutes that provide what property is subject to forfeiture, and those sections are simply amended to conform with the conviction requirement that's now going to be contained in KSA 604104. Section 6 amends KSA 604107. That's the statute that provides for seizure of property under the Forfeiture Act. That section is amended to add a new subsection O, providing that when property is seized, the seizing agency cannot induce or request a person who asserts ownership in that property to waive their interest in that property until the forfeiture proceedings are commenced. Section 7 amends KSA 604112. That's the statute that governs the judicial proceedings related to asset forfeiture. We add a new subsection H there to provide that following seizure, the person from whom that property was seized can petition the court to determine whether that seizure was unconstitutionally excessive. The plaintiff's attorney would have the burden of establishing that the forfeiture is proportional to the seriousness of the offense, and that would have to be proved beyond a reasonable doubt. The bill also provides a list of factors that the court can consider in making that determination of whether that's unconstitutionally excessive. Section 8 amends KSA 604113. That's the statute that governs in rem proceedings. The section is amended to require the plaintiff's attorney to prove the interest in property is subject to forfeiture beyond a reasonable doubt. Under current law, that burden of proof is by a preponderance of the evidence. Section 9 amends KSA 604117. That provides for the disposition of property forfeited. Current law allows the transfer of property to federal agencies, and this bill would change that to only allow transfer to federal agencies when the property was seized and forfeited under federal law. It also provides that all proceeds from the disposition of any property that's forfeited would be remitted to the state general fund, as opposed to now there's a list of where that goes, including some of it retaining with the seizing law enforcement agency. Section 10 amends KSA 604127. That's the statute you guys put in place just a few years ago related to reporting about civil asset forfeiture. I think Bob sent some information out related to that, so that was collected under that statute. And that section is amended to conform now with the conviction requirement to make sure those reports are talking about when that conviction was obtained. Current law there also requires reporting of how the money is spent by law enforcement agencies. But now, since that money is just going to be going to the state general fund, we remove those reporting requirements. And I can take any questions.
We have questions for Natalie. Very good. Thank you, Natalie. Committee, attached to both of the emails from Kathy, you'll have the Judicial Council report that Representative Curtis referenced yesterday, along with the, I think, 2 reports from the KBI. So that information is included in the information that's been distributed. A committee for both opponents and proponents, I'm going to wait until the end to have you answer or ask questions. So save your questions up. Those that are speaking before us, I'm not going to have the vice chairman time you, but let's try to keep your testimony to 3 or 4 minutes, because I'm sure we're going to have plenty of questions, and I'm happy to stay here all evening, but I'm guessing not everyone wants to stay all evening. So with that said, our first proponent is Sam McRoberts.
Good afternoon. I'm Sam McRoberts, and I am the litigation director at Kansas Justice Institute. We're a nonprofit pro bono litigation firm dedicated to protecting against government overreach and abuse. We're part of the Kansas Policy Institute. So I have written and rewritten and considered my testimony today. And since we only have about 3 minutes, I'm going to change this up a little bit. So the first kind of thing I think we should talk about is, what is asset forfeiture? And for some people, it should be well known. It's in the news almost on a daily basis. But from our perspective, asset forfeiture is when the government seizes a person's car or their property based upon little more than suspicion that the property itself has committed an offense. It's a really weird concept that the property has committed an offense. And it is a legal fiction. This was made up, maybe even hundreds of years ago. But it is a way for the government to take this property, seize it, and then move to forfeit it, which is to keep it. And again, it's based upon little more than suspicion. And I think that I've laid out in my testimony all of the issues, or at least some of the issues, that are problematic about asset forfeiture. But the one thing that I want to highlight today, and I'm hoping we can have a conversation about, is the role of government. And we don't have this conversation very often, but it's particularly important in this case. So the way that forfeiture has been set up in Kansas, all of the power belongs to the government. Because what they do is they will come in, they will seize the car, and then the standard of proof that they have to meet is very low. And then the burden shifts to the property owner to try to get that property back. And as we're probably going to hear today, after we've looked through all of the numbers over the last couple of years, the value of the property is very low. And so for a lot of people, it just doesn't make sense to try to challenge a forfeiture, even if they haven't done anything wrong. And so there's this old legal maxim that maybe we've all heard of. If you've done any sort of criminal work, either as a prosecutor or defense attorney, you've probably heard of this, which is, it's far better to let 10 guilty people go free than have one innocent person suffer. And it's Blackstone's maxim. It's been around for hundreds of years. Benjamin Franklin talked about it, except he changed the ratio from 100 guilty people to one innocent person. But those principles don't apply in forfeiture. In fact, it's completely the opposite. And so what we're trying to do with HB 2648 is to basically put the onus back on the government. It is true that it will be nominally more difficult for the government to seize and forfeit property under our bill, and maybe even more than nominally difficult. But that's the role. That's what these forfeiture laws should be about. It should be putting the onus back on the government to prove their case. And from our perspective, the best standard of proof should be requiring a conviction, that it's proof beyond all reasonable doubt. And then at that point, it is truly only the guilty property that should be taken. And it's only guilty people who are going to have property taken from them. So we would urge you to adopt HB 2648. Thank you.
Thank you. Next, we have John Luth.
Good afternoon, members of the committee. Thank you, Mr. Chairman, members of the committee. My name is John Luth. I am the Deputy State Director with Americans for Prosperity, Kansas. Civil asset forfeiture, as we just heard, is a legal process in which law enforcement can seize one's property if it was allegedly used in a crime or allegedly derived from a crime. Once your assets have been seized under civil asset forfeiture, we completely flip the foundation, the standard of the foundation of our legal system. Whereas normally that standard is innocent until proven guilty, with civil asset forfeiture, that switches and it falls upon the citizen to prove that their property is not guilty of a crime. Where else in our legal system do we so plainly tell the average citizen that unless you have the resources or the connections, your property can legally be taken from you at the utilizing the lowest legal standard of preponderance of evidence, and with not only no conviction required, but oftentimes not even a single charge pressed against them. And if you can't afford to fight us, well, too bad. This is the reality Kansans are at risk of facing every single day that we leave our current process in place. Opponents will tell you that Kansas doesn't have a problem with civil asset forfeiture, and only those who are connected to large-scale operations or large-scale crimes are the ones being impacted here. Well, thanks to the work that the legislature did a few years ago, in fact, in 2018, to instill transparency into this very process as these conversations were taking place then, we can check the facts. And the facts paint a very different picture. According to the data collected and published by the Kansas Bureau of Investigations, which has been included in my written testimony as well. In 2020, during the heat of the pandemic, the Kansas law enforcement seized $6.2 million worth of assets under civil asset forfeiture. Of that, 64% of those seizures were valued at $2,000 or less, so the equivalence of a couple of cell phones or perhaps an older vehicle. In 2021, we saw the percentage of $2,000 or less seizures actually increase to 66% of the seizures. Of the total $6 million in assets that were taken in 2020, only 8% were ever returned to the owner, and only 3% of the actual currency that was seized was ever returned. In 2021, we saw that total percentage of assets seized that was returned to the owner maintain that 8% level, but then we saw the currency returned to citizens under civil asset forfeiture drop down to 2% of the total currency collected. In short, folks, this bill will not stop law enforcement from doing their jobs, and that is not the intention at all. This bill will not even stop law enforcement from seizing someone's property. In fact, all this bill is going to do is ensure that proper due process is given to those citizens whose property is being taken from them by the government, and ensuring that they are not being burdened with the burden of proof that their property should have never been taken in the first place. This bill ensures that those property rights are not being trampled in the name of expediency or convenience of process. This bill will eliminate any semblance of a perverse incentive for agencies to use asset forfeiture as a funding mechanism by moving those collections of the seizures into the state general fund. And I want to be clear, we at Americans for Prosperity support that we should be fully funding our legal system so that they do not have to feel the need to potentially feel the need to utilize these very forfeiture processes. Finally, this bill will take a needed step into conforming Kansas law to the most recent Supreme Court ruling on civil asset forfeiture in Timms versus Indiana, where the court ruled unanimously that the Eighth Amendment's excessive fines and fees clause applies to states' forfeitures and seizures. We believe that these reforms are vital to protect innocent property owners and ensure that law enforcement can focus on their core mission of preventing and solving violent crimes. I urge you to support this legislation and show Kansans that their property rights are not only valued, but absolutely upheld in the state. Thank you very much. Happy to stand for questions.
Thank you. Jenna Butler. Jenna is online.
Good afternoon, members of the committee. Chairman, thank you so much for having me virtually. I wish I was able to be there with you all in person, but this will have to do for now. As the chairman said, my name is Jenna Butler. I serve as the Deputy Director of the Justice Action Network, and we are here in very strong support of House Bill 2648. You've heard a lot of really excellent arguments already in favor of this bill, and so I just wanted to give you a little bit of the national perspective on this issue. When our organization was formed back in 2015, when 8 of the most powerful, progressive, and conservative organizations from across the country came together, asset forfeiture was actually one of the very first issues that they agreed to work on. It's because conservatives held a very deep concern about the abuse of government power here and the protection of property rights, while progressive organizations were concerned with the disproportionate impact on minority and low-income communities. Together, those organizations have prioritized this issue across the country And as of today, 16 other states already require a conviction prior to finalizing a forfeiture. This legislation would bring Kansas in line with those states that are working to protect private property while ensure that this tool remains available for law enforcement to divest convicted criminals of the proceeds of their crime. To be sure, we agree, as with the other speakers, that this is an important tool for law enforcement. However, it must be focused on those who are actually convicted of a crime. I'm going to keep my remarks short as I don't want to repeat what others have already said. And so I thank you for your time, and I'll remain on for questions.
Thank you. Committee, we also have written proponent testimony from retired sheriff from Johnson County, Kerry Myers, and the Jefferson County attorney. Anyone else here or online a proponent of 2648? Okay, if not, questions, committee. Representative Humphreys.
Thank you, Mr. Chairman. I do have a question for Sam. But I first just want to call out Gail Finney for really bringing this whole issue to light when my first year in the legislature in 2017, and she's been working on it, and she's had medical issues and she's not with us, but I really appreciate her sitting down and explaining it to me and all the work that she's done on it. And I'm sorry she can't be with us today. And so just a quick question, Sam, if you don't mind, about you said nominally makes it nominally harder. I've had a little technical issue with not being able to dig into that section of the bill. So could you explain how harder, what you meant by that when you said nominally harder? Thank you. Thank you, Mr. Chairman.
Yeah, so I do think it's important that one of the issues that's probably going to be brought up today is what happens when the government seizes, for example, a drug mule's car. And when you look in the car, there's going to be, I don't know, bales of marijuana or, methamphetamine packages or plastic wrapped cash. That is going to be an issue. And one of the things we'll probably hear about today is it's going to be difficult in some instances to seize or forfeit the drug mule's cash and things like that. I do think that it's possible that our bill makes it a little bit more difficult for the government to prove these things, but I have full confidence that Kansas prosecutors are up to the challenge. That sometimes it is difficult to prove, that proceeds came from drug transactions. And I do think it's going to make it a little bit more difficult for prosecutors to prove the case, but I think they are well suited to do it. And so sometimes what happens, like in a forfeiture case, you wouldn't need to put on the full wealth of evidence that you might have. But here under our bill, you're going to have to convict a person. So that means you're going to have to investigate. You're going to have to spend a little bit more resources to try to get that conviction.
Thank you.
Representative Carmichael.
Thank you, Mr. Chairman. And I very much appreciate Representative Humphrey's remarks about our friend Gail Finney. She may well be listening. She listens to quite a few of our hearings, and although I haven't spoken with her recently, she's had a rough time of late, so keep her in your thoughts. I do have a question, though, for Mr. McRoberts. I may have learned something today that I never knew. I think I heard you say that under our forfeiture laws, the property committed the offense. Did I understand you correctly?
That is the basis of forfeiture laws. So yes.
Okay, I guess I studied somewhere different than you did, because my recollection was that forfeiture laws applied to the fruits and instrumentalities of the crime. So if I used my vehicle to flee from the scene of the bank robbery, that was an instrumentality of the crime and it could be seized. I also understood that the money that I had in the sack, hopefully along with the die pack, was called the fruits of the crime. And that could be taken from me as well. But in my hypothetical, I had always understood that I had committed the crime, and what the government was taking from me was the instrumentalities that I used to facilitate the commission of the crime, as well as the fruits, i.e. the money that I stole from the bank. Do I misunderstand?
I think you and I are talking about similar things. And here's why I say that. What you're saying makes sense in the context of, yes, if there is a bank robber and the government has captured the bank robber and they prove the case beyond a reasonable doubt, that is going to be a fruit of the bank robbery, right? That is.
I might,
Sure.
whether proven or not, the money I steal is the fruit. Now, I may never be convicted of it. A judge may never say it was the fruit, but in fact, the truth and reality, the money that I stole is the fruit.
I think the thing that you and I and maybe the other conferees will, I'm happy to talk about this, is in your hypothetical, you are assuming that a person can be found guilty of bank robbery. But that's the beauty of the system, is that sometimes the government thinks somebody robbed a bank when it turns out that they didn't rob the bank. And so what we're doing is putting in place certain rules to make sure that somebody who hasn't done anything wrong isn't going to lose their life savings, for example. Because I am sure that there are some instances where the government believes that money came from drug sales, but it couldn't be proven beyond a reasonable doubt, but they're still seizing and forfeiting that person's money. But I do want to go back to the property committing the crime. That is the basis of forfeiture laws, and that's been around for hundreds of years. It started with piracy, and that's how forfeiture kind of began, was trying to deal with pirates and ships and what was on the ship. So that's what I'm talking about when I say it's premised on the notion that the property committed the wrong. And that's why you've got cases that are state of Kansas v.
Right, $100,000 of the United States currency.
That's right.
Mr. Chairman, I do have some other questions, but I want to make sure everybody gets their chance. And so when I wanted to talk about the inducement provisions, but.
Representative Wheeler?
Thank you, Mr. Chair. And if I may, my understanding is that you want the person found guilty beyond a reasonable doubt before there can be a forfeiture.
Yeah, yes, generally speaking.
Okay. And in my experience, where there was significant property involved in money and drugs and, fancy cars, the defendant bonded out of jail and took off to Tierra del Fuego. Now what are we supposed to do? Because, when there's big money involved, they can make bond.
Sure. And I understand how the bail process works. And I understand that that could be perceived as a weakness within the bill. And that's why I raised the idea of the role of the government. And do we want to make sure that Kansas forfeiture laws are focused on protecting the innocent? Or do we want our forfeiture laws focused on attacking the accused?
Can you answer my question, sir?
Sure. So
the defendant took off, or the person that was arrested took off to Tierra del Fuego and is no longer available to any process to bring that person before the court. What are we to do with the property under your law?
Two things. One, I'm fully confident that the federal government and the state of Kansas can extradite people. I've seen this happen.
Yeah, you have a couple times, but not very often.
We could probably, I take it you are a former prosecutor. I've seen how the federal government works. I've seen that the state of Kansas is able to extradite people. I'm confident that our prosecutors are up to the task. But I also acknowledge the question that there are some instances where the government may not get that cash. I acknowledge that. And that's why I think it's important that we have this conversation, because not every bill is perfect. And so there will be a time that money does not go to the state of Kansas. And I think we're comfortable with that because innocent people are going to be protected.
Where does it go?
Well, I think that's something that we are happy to work with. Like if there is a solution that the state of Kansas wants to discuss, I'm happy to discuss that. And I think we're open to that. And I think that Institute for Justice's bill, I think, has a provision on that. And we're happy to consider that as well.
Further questions? Representative Carmichael.
Thank you, Mr. Chair. And Mr. McRoberts, by the way, I think I'm going to agree and disagree with the proponents and opponents on every aspect of the testimony we're going to hear today. Let me turn with you though to the inducement provisions of this bill. Give you an example. My hypothetical friend Dean. Dean had a good job, but Dean's wife had a lot of medical bills, and Dean couldn't meet the bills. And they were going to eventually foreclose on his house, garnish his wages, etc. So Dean decided that he ought to start raising marijuana in his backyard. And he had about 100 nice plants in his backyard that he was planning to use to help with his wife's medical bills. Sadly, Dean lived next door. Not sadly, I shouldn't have said that. Dean lived next door to an apartment complex where law enforcement lived, whose balcony overlooked Dean's backyard. And as a result, a warrant was issued. The plants were confiscated. Dean was charged, and a forfeiture action was commenced against his residence because he was using his backyard to grow a lot of marijuana. Dean was induced to forfeit 1/2 the value of his house, which was about $100,000 because he lived in a nice house. And in exchange for forfeiting that, what he did was he went and took out a mortgage against the house, gave $100,000 to the government, and the prosecutor dismissed the charges. Just a plain business transaction. You give me $100,000, we won't forfeit your house. That'll cover the forfeiture, and we'll dismiss the charges. Does your bill, as it relates to inducement, deal with those types of circumstances? If not, what is it it's looking for?
So I think that's a fascinating hypothetical. So I think that in our bill, there is a roadside waivers provision, and that's really what we were talking about with the inducement in terms of like somebody being pulled over and trying to be induced into agreeing on that. So I think that our bill is probably more focused on that than with respect to with your hypothetical.
Okay, so under your bill, if it becomes law, it would be roadside waivers, if you will, of interest in the property. By the way, what about the disclaimer of interest in the property? You catch me and you say, John, all that weed in the back of your car, is that yours? And I say, well, no, officer, it's not. And he says, well, then here, why don't you go ahead and sign a waiver so that we know it's not your property, and then we'll take it down and we won't sell it to make money, we'll burn it. Is that okay under your law or not?
I think the purpose of trying to prohibit roadside waivers is, again, going back to kind of the discrepancy in power between a uniformed police officer who's got a gun on his hip. He comes up to the car, and there just the imbalance of power between somebody who has just been pulled over. And I think law-abiding citizens get really nervous when police officers come up. And so I can envision scenarios where somebody just wants to make a short-term decision to get out of the situation, so they quickly and irrevocably just waive everything. And we see that even in other cases, in more serious cases than just a roadside situation and dealing with forfeiture. So you can imagine that this would be happening as well. So that's the intent, but we're happy to look at that as well.
I have more questions, but we have no more time. Thank you, Mr. Chair.
Any other questions for the proponents committee? Okay, thank you. We'll move on. First of all, do we have any neutral conferees? I don't show any. Okay, we'll move on to opponents. First I have is Sarah Washburn.
Good afternoon, ladies and gentlemen of the committee. My name is Sarah Washburn, and I'm legal counsel for the Kansas Highway Patrol. I am here today because I handle asset forfeitures for property that is seized by the patrol. We believe that civil asset forfeiture does what it is intended to do. It provides a valuable tool to law enforcement to interrupt criminal enterprises. And just like any lawful enterprise, those enterprises can be large scale or they can be small scale. But all enterprises require a few things. They require funding and they require the ability to move product. And that is what civil asset forfeiture allows law enforcement to do, is disrupt those pipelines and that economy source. It has the protections that I believe Mr. McRoberts and some of the other proponents are seeking. It has the notice provisions that were changed in 2018 to require the same notification as any other lawsuit under the laws of the state of Kansas. It requires not actual notice, not personal service, but it does require notice and service. And it requires that we mail out not only that notice of pending forfeiture, but that we send out the forms that the Office of Judicial Administration has created. The pleading standard has been reduced in 2018, and we are finding that many more people are able to complete those. And there is already a prohibition on coercing an individual to enter into any contract that I believe Mr. Roberts had referenced with Representative Carmichael's questioning and the inducement. Nothing is going to be admissible in court if it is shown that it was induced or coerced or written under duress. So those protections already exist. Some of the numbers that were quoted don't accurately reflect the totality of the interdiction system, what we do. There are certain instances where on the side of the road, after questioning, we release individuals with their property and their money, and because we haven't met the legal standard that's required of us. It is not merely a guess. It is not merely a hunch. It is not a low legal standard. The lowest legal standard is reasonable suspicion. We are required to meet the probable cause standard, which is, by the way, the same standard that is required to arrest a person. So interfering with someone's liberty to move about is required. You're required to have probable cause. You're required to have probable cause to interfere with their liberty to dispose of their property. And then we have to prove to a judge. We have to file a court case. We have to show the judge that we provided notice to these individuals, that we have met the constitutionally protected notice and opportunity to be heard provisions. And if a judge is not satisfied that those have happened, the forfeiture doesn't occur. Furthermore, requiring an individual to prove to any standard that the forfeiture is disproportionate is actually contemplated already in the Civil Asset Forfeiture Act. There is no requirement that a claimant prove that. That review for disproportionality has been in the Civil Asset Forfeiture statutes since it was written, I believe, in 1994, certainly since 2018. That review for disproportionality has always happened. And before any property is forfeited to a state law enforcement agency seeking the same, a court is required to review it for violations of the Eighth Amendment. This predates Tim's, that recent Supreme Court case, by quite a bit. I had a lot of calls when Tim's came out, and my response was always the same. Kansas was ahead of the curve. We were already protecting people from that. This is a valuable tool for law enforcement, and just like any tool, you have to be careful to use it appropriately. The protections already in the Civil Asset Forfeiture Act do that. They require notice and an opportunity to be heard, which is the constitutional standard, even to take someone's home. It requires us to be diligent. It requires us to do the investigation and to be able to prove in a court of law that this property is the fruits or instrumentalities of a covered offense. And no matter what this committee decides or what the legislature decides, the Highway Patrol stands ready to follow the law. Thank you very much, and I will stand for questions.
Thank you. Lee McGrath.
Mr. Chairman, members of the committee, my name is Lee McGrath. I'm the Legislative Counsel for the Institute for Justice, a public interest law firm. It pains me to come here today and oppose legislation in which my friends at AFP and the Kansas Public Policy Institute are endorsing. But I do so because I don't want you to make the same mistake that I made 7 years ago in Minnesota. This process fails. It fails because it doesn't take into consideration the fact that Minnesotans and Kansans are rational. Let me give you an example. This bill keeps Kansas's two-track system of criminal prosecution and civil forfeiture. What the bill does is that it changes the timing of when the criminal prosecution should go first. But what it fails to do is it fails to learn from Minnesota, Arkansas, and other states, because Minnesotans and Arkansans and others default in civil court. They do not respond to the notice. They do not, within 21 days, they do not answer the civil complaint. They rationally walk away from their property. And in Kansas, they defaulted 85.5% in the civil litigation. In Minnesota, it's 85%. In Arkansas, it's 68%. In Hawaii, it's over 90%. This is because the property owner can't afford, it is irrational to pay for an attorney in civil court when the median seizure in Kansas is $2,591. It makes more sense to walk away. This bill does not solve that problem of defaults of 85% default rate because it keeps the two-track system. The next bill solves the problem, including the next bill solves the problem of people fleeing to Tierra del Fuego and other places. I'd be happy to answer the committee's any questions about this bill and why you are in an extraordinary position here in Topeka, having enacted the reporting legislation a few years ago that I was honored to participate in. You have data. You can make wise decisions. You're in a better position than your counterparts in Minnesota in 2014 when they made the wrong decision. And every year, the default rate remains the same in Minnesota at 85%, and none of the benefits of the conviction prerequisite occur. Thank you.
Thank you. Sheriff Easter?
Good afternoon, committee. I appreciate the opportunity that you're giving me today to speak to you. There's no doubt that this is a hot button issue between, it doesn't matter which party you're in, and those type of things. A few things that I want to point out in reference to this bill has been spoke about by one of the proponents. But I will tell you as a fact, we have mules coming up from Mexico. They're given cars. They're told to report to some place in Kansas, i.e. Wichita, Kansas, at a tire shop. Drop the car off, come back the next day. They have no idea what's going on. They're getting paid to do this. We end up stopping them as they're going back towards Mexico. We build probable cause to search the vehicle, and we find a hidden compartment with $70,000 in it. This person tells us, I don't know where that came from, not my car. I have nothing to do with this. This bill tells us that we just have to release them with the money at that point. I know all of you are aware of the drug issues we're having in this state, okay? By civil law was established in 1808 in this country. So we're trying to piece out a part of that law simply because of this hot button topic. We don't agree with that. It's not about making the money. Because I can tell you last year, we received $6,559. That's it. The year before that, $10,222. Okay, so it's not about the money. What it's about is taking the ill-gotten means from these folks to further their enterprise. I understand the innocence and all those other things. I get that. I believe in our system. Okay, but civil process is much different than criminal. We also have to have probable cause. Where I'm a sheriff at, we have to make a probable cause statement, just like we're charging somebody, to seize that property. It has to pass the smell test of the DA, and then it goes in front of a judge, and they have their day in court. I understand that some people can't afford their day in court. I get that. In fact, most people sitting in my jail, their attorneys are being paid for by us at the taxpayers because they can't afford their trial attorney. So I understand that concept. The last thing that I want to point out is we get accused all the time of law enforcement's done this. Law enforcement is crooked on this. This is their personal slush fund. And I apologize to Representative Wheeler. I did find the state statute that governs how we can spend the money in this state. and it's 60-4117. We also get audited on that information. We got audited 2 years ago. It's a good system on what we can spend that money on, plain and simple. The other thing that I want to point out is by making this go to the state treasury, the problem we have with that is we already have rules in place under 60-4117 that dictate to us how we can spend the money. Now it goes to the state with nothing in this bill saying how you spend the money. So we get accused of this being our slush fund. Now we're going to be used as the tool to create the state's slush fund. That doesn't make a lot of sense to me. So with that, I will stand for any questions that you might have. Thank you.
Thank you. John Goodyear.
Thank you, Mr. Chairman, members of the committee. Good afternoon. I'll be brief. Most of the prior conferees touched on the issues that we see with House Bill 2648, but I will highlight the two big things for our municipal clients. The first being the conviction requirement, and the second being the redirection of funds from civil asset forfeiture. So one of the primary things that we are tasked with as local governments, and specifically law enforcement, is to act in a way that protects, preserves the public health, safety, and welfare. Civil asset forfeiture under the act that is currently in place is one of the tools that we use to ensure that. This bill will serve as a way to hamstring the act and will allow criminals to retain the tools and the fruits of criminal action. So as you're aware, there are many instances in which a criminal conviction is not going to be possible. For example, where the defendant dies prior to the case finishing, where the defendant is a fugitive and cannot be brought before a court. House Bill 2648 would require that seized property to go back into the hands to be returned, where it could potentially be used for negative means, criminal enterprises. Further, it can take months, sometimes years, for a case to reach final disposition, to get to a conviction. If a law enforcement agency is required to hold this property until a conviction occurs, that increased storage burden will result in increased costs. And that becomes now an unfunded mandate because of where we've now transferred the proceeds from civil asset forfeiture. The bill directs it to the state general fund without regard to costs that law enforcement agencies bear in storing these seized materials. So these are just a couple things that I wanted to highlight, Mr. Chairman. I will stand for questions at the appropriate time.
Thank you.
Thank you.
Chief Atterbury.
Thank you, committee. Since most of the previous speakers hit on most of my points, I'll try to be brief. Representative Wheeler, requiring a criminal conviction before forfeiture proceedings can commence is problematic. And you touched on one, fleeing to Tierra del Fuego. Another is that the prosecutors have a prerogative to prosecute or not prosecute. They may have co-defendants, they may have other cases, they may try to leverage testimony on somebody else and not file charges on a defendant when they very well could. That results in no conviction. Very clever criminals put proceeds in the names of relatives, friends, shell corporations, and we don't have access to those. So as a practical matter, requiring a criminal conviction before we can proceed with asset forfeiture, it's not rational or logical. It just doesn't work, as we've heard from some of our speakers. Now, to Mr. McRoberts, I wanted to look at one thing because I had to do some research on this myself. And state versus $100,000, as it was explained to me by an attorney, it's state versus $100,000, comma, proceeds from drug sales by, comma, James Smith. So yes, it's about the money, but it's about a person committing a crime. The statement that only 2% of the cash was returned in 2021. Well, the first opposing speaker pointed out that this is all reviewed by a judge. And if a judge reviewed and said that only 2% went back, I think law enforcement's probably doing a good job of meeting the burden of probable cause and fulfilling their due process responsibilities as recognized by the judge by only returning 2%. So the use of asset forfeiture in Kansas has repeatedly been found constitutional by our state court and by the U.S. Supreme Court. There are many cases that show that, and we should continue its use. It is a very valuable tool for law enforcement. It keeps money from going back into criminal enterprises to harm our citizens, your constituents, and we want to keep that from happening. And we would look forward to you not considering this for passage. Thank you.
Thank you.
Stand for questions.
Ed Klump.
Thank you, Mr. Chairman, committee members. My name is Ed Klump, and I am here today speaking on behalf of the Kansas Peace Officers Association, not the collective group like I normally do, just to get that on the record. There's a couple of things in general I'd like to say first, and I don't think you can hear this first one enough. The general principle behind civil forfeiture and the reason that many people like you sitting around a table like this in this very building years ago initiated these laws on civil forfeiture. It was rather appalling to be able to identify assets that are proceeds from a crime, ill-gotten gains, and have to give that back because you can't make a criminal case. And the aim of that was to take away the incentive to commit crimes where you weren't going to keep the proceeds if you got caught. Even if you didn't get convicted criminally, if we can prove those items were either used to commit the crime or were fruits of the crime, that those you didn't get to keep that. And I think that's an important principle that's being overlooked here. Another thing that I often hear in these discussions is an intermingling of types of things we seize. Civil forfeiture is not about evidence. Civil forfeiture is not about contraband. We can seize those things regardless of this law. Civil forfeiture is about the profits that people are making off a crime. And how do we prevent them from profiting out of crime as much as we can? And it's a totally different thing. And sometimes that confuses the conversation. That's why I bring that up. So first of all, I'd like to talk about the process that's in this bill. And right now, you can have a criminal case that's going on, and you can have the civil forfeiture process going on. That's possible under our law. Now, sometimes defendants choose on their own to separate that, but it's possible to have those both going on. What this bill proposes is we have to do the criminal case first. And if we get a conviction, then we can proceed with the civil forfeiture case. Now, one of the other opponents talked about the additional cost and things like that with storing that for that long, and that's true. But there's another aspect of this. In law enforcement, we're very attuned to people's rights and due process. So in our law today, it is possible to have your due process on your criminal charge and on the property we took at the same time. But this bill proposes to delay your due process on the property because we've got to complete the criminal case first. And we all know criminal cases can take a long time sometimes. So I want you to bear that in mind. The funds going to the general fund has been spoken about. And here's the problem, the big problem in this bill with that. It doesn't even allow us to recover our expenses in that case. And really, it's beneficial to us in our fighting crime to allow us to have more than just what our expenses are. When I was a chief of police, the first thing we prioritized with our forfeiture funds, and we did this first with federal funds, is buy money. It appalled me if we had to use taxpayers' money to buy contraband to make a criminal case that we would never get back. But I love spending drug dealers' money to buy drugs to get other drug dealers put in jail. And under this plan, we won't be able to do that. We're going to have to either not buy drugs, or we're going to have to use taxpayers' dollars to buy drugs to make our case. I think that's a very important thing. In addition to that, we have all heard great calls for more training in law enforcement, more mental health training, more of this training, more of that training. Training costs money. And our budgets are limited just as the state usually is, maybe not this year. And so, this money is one of the primary sources of a lot of agencies in their training funds. Somebody mentioned the 60-4117, the list of things we can use money on. I will remind you that was a major amendment in the law in 2018 that came from a recommendation of the Judicial Council study of forfeiture. And what we did is we adopted the very restrictive federal forfeiture rules in what money could be spent on. Last point I want to make is the waiver restrictions. If you look at how that is written, we are concerned that the way that's written, it's not just asking someone to sign a waiver. It's also, what if we just ask, is that your property? And they say no. And you say, so you say that's not your property? You have no claim to it? They say yes. Has that then invoked this waiver? And now under this bill, we have to give the money back because we asked. And I don't think that's clear in this bill, and it's a concern. And Mr. Chairman, if I may just have one more minute to talk about the Judicial Council. 2017, the Judicial Council, I think it was a 2-year study. Was that right, Mr. Chairman? I think you were on that committee. It's 1 or 2 years.
Felt like a long time.
Yeah, it was a long time. But in December of 2017, they issued this report, and there was major changes made to the civil forfeiture laws based on that. And one of the big things was the creation of the database so we could see what's actually happening in Kansas. And we supported that. We believe that data is good to have. And I want to point out that one of the things that came to light in that work is that the Kansas civil forfeiture laws was way ahead of a lot of other states. And a lot of the federal case rulings that were coming out were things like one of the opponents mentioned, we were already doing what the federal ruling said we should be doing. And that's kind of the history of our law. But the final thing I want to say about that report is the last sentence of the conclusion of that report. And it says, the committee does not consider its work to be completed. If the committee's recommendations are enacted, the committee stands ready to draft forms, instructions, willing to reconvene in future to reassess these issues once there are a few years of data available for analysis and review. When I look at these bills, there's a lot of problems, I think, in both of these bills that both sides would probably see. And having been a member of that committee, and I want to stress the Judicial Council, when they put these committees together, they have standing committees, but on issues like this, they draw in special committees where they draw in all the parties involved. And there's good, hard, solid discussion goes on and arguing back and forth about the principles that we all believe in. And that is a good method to go if we're going to look at major changes in this process again. And they offered to do that for us. And I just want to point that out. Mr. Chairman, I'll stand for questions when time's appropriate.
Thanks, Ed. Next, Greg Smith.
Thank you, Mr. Chairman. I'm Greg Smith. I'm the Special Deputy Sheriff for Government Affairs for Johnson County Sheriff's Office. Most of what I was going to talk about has already been touched on. It's kind of nice to be able to go last. However, I did want to bring up just a couple points. I believe the first proponent made the statement that the standard for seizure was reasonable suspicion, and that is not true. Under Kansas statute, that standard is probable cause, which is a much higher standard than reasonable suspicion. My testimony kind of outlines the process that was just gone over as far as how we got here, what bills, the changes that happened back in 2018 with House Bill 2459. One of those things was that data repository where you can go online and see what's going on. So I did with our department to see what we had. And every single one, with one exception, of our asset forfeitures had a conviction, a criminal conviction. The only reason we didn't have one on the last case is that the defendant died before he went to trial. But every single other one was a criminal conviction. The other thing I'd like to point out is asset forfeiture is civil. It is not criminal. It's a different court, different rules. And there is no other civil proceeding that I'm aware of where there has to be a criminal conviction first before a civil case can then be brought. In fact, there's a lot of times where a person is acquitted of a crime and then still sued by the victim or someone else for the actions that they allegedly took against the victim. Again, I think it's very important that you realize that KSA 60-4117 lays out 12 ways that we can spend the money from an asset forfeiture. I checked our records, and out of our forfeitures that we had, 75% of the funds were spent simply on reimbursing expenses for the investigation. The cost for investigations will go up. One of the other opponents spoke to that is, we're going to have to use taxpayer money for buy money rather than being able to use drug dealer money to do that with. And so I think that's an important thing. And then the last thing I'll bring up, I didn't hear a single proponent refer to the repository, to the data repository. What, did they find something? Is there some type of abuse that's going on? I didn't hear anything specific to Kansas in any of that testimony. And I'll stand for questions at the appropriate time.
Thank you. Committee, we have written opponent testimony from the KBI, the Wichita Police Department, and the Kansas County and District Attorneys Association. Anyone else here as an opponent? Okay, time for questions. Guess I'll go with Representative Carmichael first.
I have a question for Sheriff Easter, and as he's approaching the podium, I want to apologize to you, Sheriff. I made reference to Rick. I was thinking of our current Chief Gordon. Rick was a reference to your former boss, Rick Stone, whose picture I happened to be looking at last night.
I took it as you were referring to me as my dad, Rick, because I get that.
Well, as a matter of fact, I spent many pleasant evenings on third shift with your father, but we can discuss that later. As I understood your testimony, were you saying that your civil asset forfeitures in Sedgwick County were $6,500 in one year and $10,000 in 22 and another, or was I misunderstanding?
No, that's correct.
Okay, well, that doesn't square with your story about $70,000 that you seized from the car that had been at the body shop. Well, what happened to all that money?
10 years ago.
Okay, so of your entire budget in Sedgwick County, for the last year you had numbers, only 10,000 of it came from civil asset forfeiture?
Well, no, what we have seized and then filed paperwork on for probable cause to be able to officially seize after a judge orders it was $6,559 last year.
So if we got rid of civil asset forfeiture, as far as your department is concerned, it wouldn't be a significant impact in your budget. I mean, that's not the cost of repairing the bumper on a patrol car that's involved in a fender bender.
For last year, no.
The year before?
10 years ago, there was $4 million.
Yeah, but that's gone for whatever reason.
Yeah. So it goes by year, sir.
So last year and the year before, we're talking about virtually nothing in your budget.
Correct.
Okay. I have another question for Chief Atterbury if we have time.
We do.
Chief Atterbury, as I recall your testimony, you talked about people who assert that this is a slush fund for the civil asset forfeiture, is a slush fund for law enforcement. The people say that. I think that's what maybe I confused that with a different
No, but I can address it.
Never mind. If it was somebody else out there who said that, was it Sheriff Easter? Sheriff, civil asset forfeiture under this bill, it becomes a slush fund for the SGF?
We've been accused of it being a slush
right, and so now you're saying, but this would be
would
a
it
slush
not,
fund for the legislature almost.
Would it not be the same for you?
The reason that I
no rules in place.
Right. The reason that I ask, though, is the issue, I think, is that right now with the money going directly to law enforcement, there is a financial incentive for law enforcement to do seizures. Now, your office apparently isn't that active in that, thank goodness.
Or the criminal.
But but the question I have, though, is, do you see that there's a difference here when we talk about motivation? If the department that is doing the seizing is dependent in some measure on civil asset forfeiture for their funding, they're going to have an incentive to seize more. The legislature, we don't do the stopping of the vehicles and the seizing. And so, yeah, we might benefit from the money, if you will, but we don't have the motivation to go out on the street and seize it. Do you understand? And that impacts on the image of law enforcement. As I said several years ago, to the offense of many, some see our law enforcement as highwaymen. Now, it's not me that says that, but a lot of people think that you're out there looking for Colorado tags, you're looking for white vans that are transporting hundreds of $1,000s of cash between Colorado and Missouri, and that what you're really doing is law enforcement is acting as highwaymen. Your office is obviously not doing that because you're not doing very well. But can you address that concept and the concern people have for the integrity and
So I stood up here in 2018, gave testimony. We had people in with you guys that were accusing us of using it as a slush fund. That was testimony. That's where I get that from. There's a difference between what you're saying is an incentive, which I understand that concept, but us just using it as a slush fund, absolutely not. And that's what we've been accused of. We've been accused of being highwaymen. We've been accused of murders as being murders. We're being accused of being racist. You name it, we're being accused of it. So I understand, like I said in the beginning, what a hot button topic this is. I'm not into government overreach whatsoever. Do I believe this is government overreach with the checks and balances that are in it, including a judge and the law as it is written now in 2018? I don't think it is. And that's what I'm arguing for.
And I certainly didn't mean to ever imply that you fit within any of those categories. Because as you know, I'm very glad you're my sheriff. And if I lived in Bel Air, Chief Atterbury, I'd be happy for you to be my chief. Thanks.
Any other questions for the opponents? Okay, very good. Closing the hearing on 2648. I'll open the hearing on House Bill 2640, and we'll have Natalie come up and talk about this one, please.
Thank you, Mr. Chairman. House Bill 2640 would create a new process for criminal forfeiture of property. So this would apply to property with a value of less than $100,000 that's used in the commission of certain crimes. Section 1 names the act, the Criminal Forfeiture Act, and applies the act to seizure and forfeiture of property with a value of less than $100,000 that is used in the commission of a crime described in 604104, which is the act, the Civil Asset Forfeiture Act that we were just talking about. So it would apply to the same list of crimes that civil asset forfeiture currently would apply to. Essentially, the current process of civil asset forfeiture will remain in place for property that's valued over $100,000. This new process will apply to property that's valued at less than $100,000. Section 2 provides for definitions that would be used throughout the act. Section 3 provides that a court that has jurisdiction over the criminal case will also have jurisdiction in the related forfeiture proceeding. That will happen as part of the criminal case. A hearing on that forfeiture shall be conducted after the defendant has been convicted of the crime giving rise to forfeiture. Section 4 authorizes the court to issue an ex parte order to seize personal property. It would be able to be seized without that order. If it's seized incident to a lawful arrest, there's probable cause to believe that a delay would result in the removal or destruction of the property, or it is the subject of a previous valid forfeiture judgment. Section 5 provides that real property would not be able to be seized without a court order. Such court order shall not be issued unless the defendant and any other person with interest in the property is given notice and opportunity for a hearing. Section 6 provides that no property rights exist in stolen property or contraband. Section 7 provides that when property is seized, a law enforcement officer would be required to give an itemized receipt to the person from whom that property was seized from. Section 8 provides that real property that's a homestead, money that is less than $200, or a motor vehicle with a market value of less than $2,000 would not be subject to seizure or forfeiture under this act. Section 9 prohibits a law enforcement officer from requesting a person to waive their interest in property and provides that any document purporting to do that would be void and unenforceable. Section 10 provides that title to property vests in the state when the court issues a forfeiture judgment. Section 7 provides that if a defendant is represented by a public defender or appointed counsel, that person would continue to represent that person in the related forfeiture proceeding. If a defendant or an innocent owner engages in pro se litigation, the prosecutor would be able to engage in conversations with that person with the purpose of trying to settle this dispute. Section 12 requires a prosecutor to perform a reasonable search to identify people other than the defendant who might have an interest in any property, and then the prosecutor has to give notice to those people that they find. And the section also provides what language is required to be in that notice. Section 13 provides that after property is seized, a defendant or a person with interest in the property can petition the court to conduct a hearing on that seizure. That hearing has to be conducted within 30 days, except that a one-time 10-day extension could be granted for good cause. The section also provides the list of circumstances under which the property should be returned and allows the court to return the property for purposes of obtaining counsel if that property is no longer needed as evidence. Section 14 provides that when a prosecutor seeks to forfeit property, the prosecutor would be required to file notice. And the section, again, provides what's required to be in that notice. If the prosecutor does not properly file that notice, then the court would order the return of that property. Section 15 provides that the property may be forfeited if the state secures a conviction for a crime described in KSA 604104 and establishes by preponderance of the evidence that the property is an instrumentality of or proceeds derived from that crime. Nothing here would prohibit property from being forfeited as part of a plea agreement or a grant of immunity to participate in law enforcement action or testify at a trial. The conviction requirement of this section could be waived if a prosecutor shows by preponderance of the evidence that the defendant died, was deported, abandoned the property, or fled the jurisdiction. Section 16 authorizes a defendant to petition the court to determine whether a forfeiture is unconstitutionally excessive. It also lists the factors that the court can consider in making that determination. It also requires that the court cannot consider the value of the property to the state when determining whether that forfeiture was unconstitutionally excessive. Section 17 provides that property that's encumbered by a security interest would not be able to be forfeited. That property would be returned to the secured interest holder up to the value of their interest. If it's not returned, that secured property holder can petition the court for return. They would be required to prove by preponderance of the evidence the validity of their security interest. If the prosecutor disputes that valid security interest, then the prosecutor would have to show by preponderance of the evidence that the interest is valid, the interest resulted from a fraudulent conveyance, or the secured interest holder consented to the use of the property in the crime. If that burden is not met, then the property would have to be given back to the secured interest holder, again, up to the value of their interest. Section 18 provides similar protections for innocent owners. That property would not be subject to forfeiture. It would have to be returned to the innocent owner. If it's not returned, that innocent owner would be able to petition the court. That petition would include a statement that describes the innocent owner's interest or regular use of the property, the relief sought, and any additional facts that would support their argument. The court would be required to hold a hearing. If the prosecutor disputes the validity of that interest, then the prosecutor would have to establish by a preponderance of the evidence that the interest is valid, the innocent owner does not regularly use the property, the innocent owner has knowledge that the property was used in the crime, or the innocent owner was not a bona fide purchaser without notice of defect in the title for valuable consideration. No information that's provided by an innocent owner could be used as evidence in the criminal proceeding, but they would be able to testify at trial. Nothing would prohibit them from testifying at trial if they want to. A defendant would be able to invoke the right against self-incrimination or the marital privilege during a forfeiture proceeding. Section 19 provides that if a prosecutor fails to meet the burden in a forfeiture proceeding, then the court would be required to dismiss the case and order return of the property. If the prosecutor does meet that required burden, then the court would enter the judgment forfeiting the property. Section 20 provides that the court can order forfeiture of substitute property up to the value of the property that would otherwise be subject to forfeiture if that property is beyond the court's jurisdiction or cannot be located. Section 21 provides that the defendant is not jointly and severally liable for forfeiture awards owed by other defendants. When that ownership is unclear, a court would be able to order each defendant to forfeit property on a pro rata basis. Section 22 provides for appeals. If an owner's claim prevails by recovering at least half of the property, then the court would order either the seizing agency or the prosecuting attorney to pay reasonable attorney fees, cost, post-judgment interest, and any interest that was actually paid during that time. Section 23 provides that if a court orders the return of the property, the law enforcement agency holding that property has to return it within 5 days. The owner would not be subject to pay any expenses of moving that property, like towing or anything like that. The law enforcement agency that's holding the property would be responsible for any damages to the property while they were holding it, any storage fees or related costs. Section 24 provides that when property other than money is forfeited, the court would order the sale of that property, and then it also provides what the proceeds from that sale could be used for. And then finally, Section 25 amends KSA 604103. That's the jurisdiction statute in the Civil Asset Forfeiture Act to clarify that that act will only apply to property seized with a value of more than $100,000, and that all other seizures would be governed by this new Criminal Forfeiture Act. And I can take any questions.
Representative Heiberger.
Thank you, Mr. Chair. The way I read this, if property is seized from someone who then flees the jurisdiction to Tierra del Fuego or otherwise, there would still have to be a criminal case filed in order for the seizure, the property to be forfeited. Is that accurate?
So that is one of the circumstances in which the conviction requirement can be waived, but that's kind of an interesting question. It doesn't really say whether the criminal proceeding has to be filed in the first place. I'll take a closer look at that.
Any other questions for Natalie? Glance online. Okay. Thank you, Natalie. Proponents. Okay, ready for proponents. Representative Osman.
Thank you, Chairman Patton, Ranking Minority Carmichael, members of the Judiciary. Thank you for hearing my testimony on HB 2640. So, my wife and I don't always see each other eye to eye politically, and it makes for some really interesting discussions across the dinner table. But I can tell you that when we do agree on something of a political nature, it's big. It gives me a heads up that whatever the idea or concept is, it's shared by a wide variety of people across the political spectrum. And the elimination of civil asset forfeiture is one of those ideas. And you could just take a look at it from the proponents that come here today. I mean, you look at the American Civil Liberties Union, the Americans for Prosperity, the Institute for Justice. It's a wide gamut of political spectrum, and they're all here in support of eliminating civil asset forfeiture. I would also reference Mr. McGrath, who is going to be speaking. He's an expert in this field, and I would pay attention to his testimony. But I want to talk about if you've ever had the chance to explain civil asset forfeiture to somebody that has no idea what it is. I have, and I don't care where you are politically, the result is always the same. First, their eyes get wide, then they get confused, then they get incredulous, saying, how in the world could this possibly exist? And I could tell them about the Comprehensive Crime Control Act of 1984. how it ramped up seizures across the country, established equitable sharing across law enforcement agencies, and then what happened to those seized funds. I could tell you that it often goes entirely into law enforcement, which creates a perverse incentive to continue to seize those funds. But, and pardon the pun, I don't need to get into the weeds on this issue. On its surface, people just inherently know that civil asset forfeiture is wrong. Now, I haven't even gotten into the question of what happens to the assets once they're seized. It's called civil asset forfeiture because it becomes a civil matter. Your property is separated from you. Your property doesn't have rights. Your property doesn't have a presumption of innocence. Your property doesn't have a constitutional right to counsel. In short, in many instances, your property is gone. It ceases to be your property. You don't need to be convicted of a crime. You don't even need to be charged with a crime. That's just what happens. So HB 2640 changes all of that. It converts this to criminal asset forfeiture. First, that means that personal property can't be seized unless it's incident to a lawful arrest. They become tied together. And second, it means that a court has jurisdiction over both the criminal case and also over the related forfeiture proceeding. This allows the criminal court to take care of both issues either simultaneously or concurrently. It'll save both time and resources. Third, it allows defendants to maintain their constitutional right to counsel, both for them and for their property. And finally, it requires that all property seized go into the state general fund and not directly to law enforcement. Now, I want to make perfectly clear that this bill is not an attempt to defund the police. If a law enforcement agency is lacking in funds to effectively do its job, let us have that conversation. But that conversation is separate from this bill. If making your budget is contingent upon civil asset forfeiture, something has seriously gone wrong with your budget. HB 2640 is a concept and legislation that is long overdue for the United States. But for now, I'll settle on just Kansas. Let us be an example to other states that they can look to us for inspiration and for duplication. Thank you very much for your time today, and I stand open for questions at the appropriate time.
Very good. Thank you. Lee, you're back up.
Mr. Chairman, members of the committee, I thank you for the opportunity to testify enthusiastically for this bill. This bill is the right one. This bill is $1 million bill. That's all that it covers. It draws a threshold. Anything above $100,000 is excluded from this bill. It draws a separate wall. Anything that is done by in collaboration with the federal government in joint task forces is excluded by this bill. This bill focuses on Kansans, and Kansans who today default at a rate of 85% in civil court. As I suggested to you earlier in my testimony, don't be like Minnesota. In this testimony, I invite you to be like Nebraska, New Mexico, Maine, and North Carolina. In those states, they had the two-track system of civil forfeiture and criminal prosecution, and they merged them together. And the great advantages of merging them together is that 100% of the time the case goes before a judge. Today in Kansas, only 14.5% of the time cases go before a judge because the default rate is 85.5% in civil court. Prior testimony suggesting that a judge is reviewing these cases is true hypothetically and in 14% of cases. It is not true in 85.5% of cases when Kansans default in civil litigation. There is no civil litigation here. In this bill, the processes are united into one process. This bill doesn't affect police officers and highway patrolmen's ability to seize and take possession. Overwhelmingly, this bill focuses on the work of prosecutors, the work of taking title through forfeiture litigation, transferring the fruit and instruments of crime to the state. And under that $100,000 threshold, we're talking about $1 million worth of property a year. Additionally, Representative Willard, this bill is very pragmatic. The conviction prerequisite in criminal court is waived if the defendant flees to Argentina, to Tierra del Fuego, if he dies, if he abandons the property, or if he flips and agrees to support other prosecutions. It is pragmatic. And so it has all the flexibilities that a prosecutor needs to negotiate a plea agreement and to file a motion should the defendant die. No criminal charge is needed. All that is needed is a filing of a motion in the court. Additionally, this bill respects law enforcement's costs. It allows law enforcement to be reimbursed up for their non-personnel operating costs. And given that the median seizure in Kansas is currency seizure is $2,591, that implies that all of the forfeited proceeds will go to law enforcement. Very few will be left over to go to the general fund. So in conclusion, Mr. Chairman, you have a piece of legislation that has been proven successful in a border state of New Mexico. You have a piece of legislation that has been enacted and is working in Nebraska. You have a piece of legislation here that Maine just enacted last session. It is a piece of legislation that ensures a charge and conviction, avoids the problems of default at Kansas's rate of 85%, and because it is in criminal court, provides a public defender for the indigent. And so in this way, Kansas is adopting the process that Kansans are due, a process that requires a conviction as a prerequisite to a rather simple transfer of title to the state after that occurs. Mr. Chairman, thank you.
Thank you. John Luth, are you written? Well, then you're just on the list for the heck of it, huh? Okay, I'll mark you off. Proponents written, I have Sam McRoberts again for Kansas Justice Institute, the ACLU, and the National Coalition for a Civil Right to Counsel. Anyone else as a proponent? Okay, questions, committee? Representative Neely.
I guess this is not as much a question as it is a statement. Him bringing up that the majority of the money would be returned to law enforcement, that was important to me. I've always had a problem with, for example, the federal windfalls that come back to the state of Kansas, and the state decides to keep it. That's telling me that the state knows how to spend our money better than we do. And I guess maybe my suggestion would be, instead of the money going back to the general fund, that a fund be set up for law enforcement and all money be returned to law enforcement from that fund, because I don't think the state has any right to it. That's just my personal opinion.
Representative Neely, I'm not certain your understanding of how the federal dollars flows back is correct, but I'm not sure who to ask. Maybe you are correct.
Mr. Chairman, Representative Neely, there are two jurisdictions when it comes to forfeiture related to drugs. There's Kansas jurisdiction, and that's what this bill talks about. That's the $1 million. There is also the federal jurisdiction, and that's about a $4 million program that this bill allows joint task forces to continue to use. Doesn't touch joint task forces. Now, once the federal government does engage in either civil forfeiture most of the time, but periodically criminal forfeiture at the federal level, it can reimburse local Kansas law enforcement up to 80%. And so most of that $4 million comes back into Kansas law enforcement when the case is federalized under the equitable sharing program that this bill doesn't change.
And I guess I didn't explain it or in depth. I wasn't even referring to law enforcement. I was more even referring to our tax issues that we have money returned to the state of Kansas from the federal, and it has to flow through the state. And rather than being returned to the nice people of Kansas, is often kept in the state through the state. So, but I do appreciate your explanation. Thank you, sir.
You're welcome.
Representative Heiberger.
This is for Mr. McGrath too.
Sir.
I'm still confused about what happens when the defendant flees the jurisdiction. If I go on the state e-file system and I want to file a motion, I have to find a case to file it in. I mean, unless this motion is a pleading of some sort, then I don't understand how it works.
Under this, Mr. Chairman, Representative Heiberger, under this model, the goal of this model is to have the criminal charge as the leading document and the forfeiture notice as the subsequent document, so that it is treated like sentencing, that after the suspect is convicted of a charge, the judge who has heard all the evidence can easily decide. Should the defendant die, the prosecutor can go into court, reference the criminal case number, and file a simple motion saying, Your Honor, we're dropping the charges. There's no one here to convict. And according to this bill, the judge can automatically transfers title to the state. And so I hope it is a pragmatic way to address fleeing, abandoned property, flipping, and other fleeing of death and deportation.
In the case of somebody who flees, there still has to be a criminal charge that had been filed before you can file this motion.
Yes.
Okay, that's what I wanted to know.
So we are in criminal court, and that's the vehicle to which this forfeiture notice gets attached.
Representative Wheeler.
Thank you, sir. And I think perhaps maybe I misunderstood or maybe I got lost, but somewhere in your presentation, you with your fabulous gesticulation, sir, said something about, and this will never be in conjunction with a federal case or something. Did I understand that correctly?
Let me try again, Mr. Wheeler, and thank you for noticing my enthusiasm and my affection for being here in Topeka again. So thank you. The bill draws two lines. It is the second line that involves the feds. It is the second line that says when the Shawnee or Sedgwick County law enforcement signs a joint task force agreement with the United States Department of Justice and the DEA, this bill doesn't apply. And so Sedgwick County in 2021, for example, did $8,924 received $8,924 from the federal government. Under the federal government's forfeiture program, done in federal court, Sedgwick, that would not change under this bill because that's the federal jurisdiction. Johnson County received $283,000 from the federal government for seizures that they may have done. Johnson County may have done as part of a joint task force with the DEA, and then federalized to the U.S. Attorney in Kansas City. That would not be reached by this bill. This bill is Kansas, and only Kansas law, not affecting joint task forces in which sheriffs and counties enter into with the United States Department of Justice.
So if I may, I'm from Finney County, Kansas.
Finney.
That's Garden City. The DEA, during substantial amount of the time, over 10 years, has been present in Finney County, Kansas with an office. They left. And that was after I was in a position of authority there. But they have made a decision that they made a very serious mistake in leaving Western Kansas. And so now they're back. Now, the police department, the sheriff's department have put people in the highway patrol, have put people on that task force. Is that the joint agreement?
Yes, sir.
With which you mentioned?
Yes, this bill does not change anything in Finney County as it relates to what you're talking about.
The county attorney received proceeds from federal seizures as well, and I never signed anything. But I guess it's just because we have officers on it.
This bill would not change anything as it relates to the joint task forces, anything regarding the compensation that the Department of Justice up to 80% gives back to Finney County. This is the second threshold. This is the second cement wall inherent in the bill. The first one is the $100,000 threshold. But I can give you complete assurances.
You're meaning that it does not affect the criminal forfeiture.
This bill does not affect the seizures by a joint task force in Finney County. This bill does not affect the U.S. attorney from the U.S. attorney is probably from Wichita, I suspect, in Finney County. I'm guessing the U.S. attorney can bring a federal civil case. The U.S. attorney can bring a federal criminal forfeiture case. All of that is unchanged, is on the other side of Representative Osmond's wall as it relates to the $1 million that is in play here under Kansas law.
Thank you, sir.
Representative Carmichael.
Thank you, Mr. Chairman. As I watch two fine trial lawyers at work, it reminds me of the day a judge threatened to handcuff both of my hands to the podium if I did not refrain from gesticulating in his court. So I'd like to follow up, though, on Representative Neely's question, perhaps if the chair and Ms. Washburn would be kind enough to allow.
Yes, go for it.
As you're approaching, Ms. Washburn, Representative Neely was asking questions which related to how much of civil asset forfeiture money might end up in the state general fund. And I know from your experience, you have certainly done state civil asset forfeitures, and I know you've worked hand in hand with the feds on civil asset forfeitures. Maybe if you haven't worked hand in, I didn't mean to put it that way, but you're well familiar with, I think, what goes on there. Does money from either state or civil asset forfeiture end up in the Kansas State General Fund, other perhaps to the extent that it comes back to the patrol, but it comes directly to the patrol. I don't think this money ends up in the SGF, but perhaps you know better than I.
My understanding is that the money is returned directly. When it comes to federal agencies, it's returned to anyone who has partnered with the feds and has signed an equitable sharing agreement with them. So in the case where Representative Wheeler was discussing money coming to the county attorney's office in Finney County, they would have had to have signed an agreement with the feds. We obviously have that agreement with the feds, and the money does come back to the agencies who have signed that. It is not my understanding that in any way, shape, or form that the state of Kansas can sign that agreement with the feds, so the money could not be directed to the general fund, as I understand it.
That's consistent with my understanding. With respect to state forfeitures, does the money end up in the state general fund?
No, very similarly, it comes back to the seizing agency, and then at that point, we may disseminate certain percentages. For example, if the county or district attorney handles it on our behalf, they receive a percentage set by statute. And in certain instances where a non-highway patrol canine has been utilized, we provide a percentage of the proceeds to that officer's agency as well for their assistance in the investigation.
But as far as you know, the proceeds of the civil asset forfeitures under the Kansas Civil Asset Forfeiture Scheme do not end up in the state general fund.
No, sir, but because we are a state agency, the legislature does have oversight over our spending of those funds.
Right, your budget is, no matter where the money comes from, grant, forfeiture, or God, the legislature still approves your budget.
Absolutely, and approves any expenditures from the specific forfeiture funds.
Thank you.
Any other questions for the proponents? Representative Neely.
Did I misunderstand that this bill, anything, would a portion of it would end up going to the state, but that their funds that they're using for their operating funds would be returned to the sheriff or police department, but the rest of the funds would go where, sir?
Mr. Chairman, Representative Neely, you are right. Under this bill, with its two limitations, law enforcement would be reimbursed for its operating costs, including its controlled by money. And my observation was that with a median currency seizure of $2,591, we're talking about all of it in almost all of the cases going to law enforcement. So that's unchanged from today's distribution, which is 100% to law enforcement under Kansas law. Now, there are certain situations where the amount of the forfeiture is going to be above all those costs. The cost of investigation, the cost of the control, the reimbursement of the buy, the cost of the prosecutors, the cost of the public defenders. And in those few cases, the money is directed to the general fund.
Representative Neely, I'm going to have Natalie point us to that section and explain it as well.
Thank you, Mr. Chairman. I just want to clarify that this bill doesn't really actually touch on where the money goes at all. It just talks about what the money can be used for. And so that is on page 8, starting at line 30. All those provisions are contained in section 24. So that money can be used to pay restitution, satisfy the recorded liens, pay reasonable costs, reimburse the law enforcement agency, reimburse the prosecuting attorney, the public defender, or the court-appointed attorney. So it doesn't necessarily say where that money goes. For example, the public defender's office. If you want to reimburse the public defender's office, that might need to come back through the state general fund to then be redirected to them. So it doesn't set up any new funds, and it doesn't direct the money to go anywhere.
Other questions for the proponents? Okay, we'll move on to neutral. Do we have any neutral conferees? Okay, opponents. And it looks like we've shuffled your order just for the fun of it. Ed Klump, you're up first.
Thank you, Mr. Chairman, committee members, Ed Klump. And again, I'm here for the Kansas Peace Officers Association on this bill. I want to just go back to one thing about the the criminal conviction requirement that I want to kind of talk about. And that is there can be a case, and let me give you a scenario. You can have a case where perhaps you stop a car and for whatever reason, maybe the driver's drunk and we impound the car and we search it incident to the impoundment of the car. And we find in the vehicle a satchel that's got $70,000 in it, and the scales to weigh the cocaine, the bags to put the cocaine in, and 2 big bags of cocaine. And we seize that money. Now we seize all the other stuff as evidence. It has nothing to do with forfeiture. But we seize that $70,000 because it's pretty clear that that's drug money. But the driver of the vehicle doesn't own the vehicle, and the driver says, I had no idea that bag was there. The owner of the vehicle says, hey, it wasn't there when I loaned it to him. It is up to the state to prove which one had the criminal intent, if either of them. Maybe there's a third party threw it in there. But it's up to us to prove beyond a reasonable doubt who had the criminal intent on that. And in a case like that, you may never reach that. You may never be able to reach a probable cause level to arrest a person for that offense. But we clearly have an offense because of the circumstances we find that money in. And under this bill, and I believe under maybe the previous bill, we couldn't do anything on that forfeiture. We'd have to get that $70,000 back to somebody or put it in the state fund, maybe, if it was considered abandoned for some reason. But I just point that out, that there are cases where we can prove that that's fruits of a crime, but we can't prove who the individual person was that committed that crime. So I just throw that out there. So what this bill does is it actually keeps the civil forfeiture process. It just makes the change to it that it has to be over $100,000, and keep that phrase in mind, over $100,000. Okay. And then it creates this whole new process for a criminal forfeiture, which is anything where we seize less than $100,000. I emphasize that for the reviser's sake, because it's something that needs to be looked at in the bill. Because if I have exactly $100,000, I'm not sure what we do with it. So that's something that needs to be fixed in it if you move this bill forward. How many of you were around with all the discussions several years back about the crime or a crime used in the statutes? Anybody remember that? That consumed a whole bunch of committee time, probably 10 years ago, because we had a place in the statute that talked about the crime, and it was causing problems in cases. And the prosecutors came up and made a good argument of why it needs to be a crime. And I'll tell you, this bill refers to the crime leading to the forfeiture or the seizure. And sometimes we have multiple crimes, and sometimes we have multiple defendants with varying crimes, all involved in the same case. And I think that's a phrase that may be problematic that you need to look at in this. I talked about the transfer to the state general fund. The proponent talked about how in this case we get reimbursed with our expenses, and that's true. We get reimbursed with expenses in this case, but it doesn't necessarily transfer any money to us that we can use in other drug investigations. So even in this scenario or in this bill, we would end up having to use taxpayers' money to investigate other drug crimes, or we'd have to just not do those drug buys, because not every case we make on a distribution charge do we seize assets that we forfeit. Sometimes we have the case on the individual, but we have not found any assets that we can seize. And so there's a lot of drug cases that go to criminal court that there isn't any assets seized for forfeiture. And I talked about the waivers. That's still in this bill and still an issue. And I want to also point you to a hardship phrase, and that is on section 16 of the bill, subsection B6 and 7, found on page 5, lines 42 through page 6, line 3. And it creates a hardship provision there for vehicles, I believe, that if the defendant shows there's a hardship, then the court can return that vehicle based on that hardship. And you know, that's probably not all bad to at least consider. But the part of that that troubles us in this is not only a hardship on that defendant, they can also show, does it cause a hardship on the defendant's family? And then we would get that vehicle back, regardless of whether it was used in the crime, you know, one of the things that were used in the crime. So just some things like that. There's a lot of things like that in this bill that really need to be looked at hard and make sure they're right, clean them up if this bill was to go forward, which is another good reason to not pass this bill, at least today. Mr. Chairman, I'm hungry. I imagine all of you are too. I'm going to sit down and answer questions at the appropriate time.
Thanks, Ed. Sheriff Easter.
Well, good afternoon again. Jeff Easter, representing the Kansas Sheriff's Association. Just a few things to point out on this particular bill. First off, I do want everybody to understand that, you know, a lot of when the asset forfeiture stuff came up in 1994 with the asset forfeiture laws, what we were finding is with the gangs, crack cocaine being the epidemic that it was then, you went out, bought $1,000 worth of powder cocaine, and you could make $2,000 to $4,000 off of it by mixing it. And so a lot of the drug dealers that we were taking off had $2,000 to $4,000 on them. We think that the $100,000 mark is just way too high. These are the same people that were also causing the violent crime taking place. We're still seeing it now. Now it's methamphetamine instead of crack cocaine. The other thing that I would like to point out real quick, and I know the gentleman testified as a proponent of this bill, but it is not clear to us exactly the discussion that you guys were having on task forces. And the reason I say that is on page 9, lines 11 through 14, it states, nothing in subsection C shall prohibit a state law enforcement agency from participating in joint task forces with the federal government. Any proceeds from such task forces shall be deposited in the state treasury to the credit of the state general fund. First off, sheriff's offices and police departments are not state agencies. So is this precluding us from participating in task forces? I could see if it was passed as this, that's exactly how it could be interpreted. Secondly, when it says any proceeds from such task forces shall be deposited in the state treasury to the credit of the state general fund, that can be interpreted as if you are seizing on federal stuff, it will be given to the state treasury as well. So I understand what he's saying, but that needs to be cleaned up for how he testified, that it doesn't affect those two things, because the way it's written, we believe that's exactly what it says. We can't participate in task forces because we're not state. The last thing that I would point out, you know, there's two similarities to both of these bills. One bill or both bills require all funds to be given to the state general fund. And again, there's no language on if it's given to the state federal fund or state treasury, how that money is going to be spent, unlike what's in state law now that tells us exactly how we can spend it. So if this is something that obviously wants to be done with the state treasurer, I agree with Representative Neely, then if this is going to pass out, that should be for law enforcement. And that's where that money should be put into. You know, there's been some comments about, and I even had in my county, obviously we don't have that much asset forfeiture anymore. The criminals have gotten much smarter. They deposit all their money at Wells Fargo now and use it on their credit card. So training is a big issue for law enforcement. There's a lot, as Ed had said before. My commission was generous enough to add that as a budget item. Okay. There is a lot of equipment that is needed. Every 5 years, all of our vests need to be replaced. So far, the commission has not given us the money for that. So it is asset forfeiture that's affording that, or we have expired vests because there is no budget item for that. So I understand why we're having these discussions. Just understand that when that asset forfeiture is being used. It's being used for other or for items that it absolutely is needed in law enforcement that sometimes those jurisdictions can't afford and their commissioners can't afford. Thank you.
Thank you. Greg Smith.
Thank you, Mr. Chairman. Our testimony pretty much mirrors what Sheriff Easter had for the Kansas Sheriff's Association. We are very concerned, though, about that term state agencies because it seems to preclude us from participating in a federal task force at all. We are not a state agency. Another thing that came up, we did the research. We didn't include it in our testimony, but after hearing the proponent, I'm even a little bit more confused about what this bill actually does than what it doesn't. According to NCSL, the states that he mentioned, Maine, Nebraska, New Mexico, North Carolina, are all listed as having completely abolished civil asset forfeiture. So I don't know if that's because it's attached to a criminal thing now or what, but according to NCSL, they don't even do it anymore. So I'm not sure how this follows these other states. And I'll stand for questions at the appropriate time.
Thank you. Sarah Washburn, welcome back.
Starting to get a very strong sense of deja vu here. Good evening. I will be very brief. Much of our written testimony on House Bill 2640 mirrors our testimony on 2648. We have some of the same concerns because many of the provisions are similar. We would encourage this committee to really think strongly about completely doing away with civil asset forfeiture. It has the oversight for spending of any forfeited proceeds. The legislature supervises all state agencies. County commissions and city commissions supervise spending by local agencies. It is overseen by a judge. I do enough of these in the state court. I can tell you that while I can't debate that probably 85% of them are done under a default, that is still reviewed by a judge. I have to meet the burden. I have to show that judge that I have provided notice to these individuals. I have to show the judge that I have let these people know about how to claim this money if they choose to do it. And I can tell you right now, I have not met a judge yet who will not hold my feet to the fire to do that. And while it is not always required, if I know where someone is, if someone happens to be in custody, we do serve them personally. We have the sheriff go and serve them. The protections are in place, ladies and gentlemen. They are there. If the notice and an opportunity to be heard is the requirement under the Constitution of the United States, those requirements are in the Civil Asset Forfeiture Bill. And the balance that we're seeking here is between an effective tool for law enforcement to interrupt criminal enterprises and protecting innocent property owners. That balance is also in the Civil Asset Forfeiture Act. I want to leave you with one example that I don't think is at all contemplated by this bill and concerns me greatly. And that's human trafficking. Human trafficking is a covered offense under the Civil Asset Forfeiture Bill. But in looking at the definitions of proceeds, my concern is that proceeds does not contemplate money or property or other securities that is obtained from the sale of a person, either for sex or for labor, because this definition says it's obtained from the sale of property or contraband. And criminally speaking, we do not prosecute the victims of human trafficking in this state by law. There are defenses in place. So an individual who is being themselves trafficked is driving another trafficking victim so that the second trafficking victim can be sold, is stopped in a vehicle that belongs to the trafficker themselves. There is no way we can reach the trafficker. They're out of state. We can't charge them criminally. The only thing that we can do to that trafficker is take the vehicle, which provides for the transportation of what he is selling. And unfortunately, in this case, that commodity is a person. Under this bill, we would not be able to do that. We would not be able to interrupt that enterprise. And we certainly are not going to charge two victims of human trafficking with an offense just so we can try and get the car in which they have no interest anyway. The Civil Asset Forfeiture Act allows us to do that. It allows us to interrupt not just drugs, not just money laundering, but human trafficking enterprises as well. And quite frankly, that's a very valuable tool to us. And I would ask this committee to think very carefully before overturning that Civil Asset Forfeiture Act. It has the balance you're looking for, provides that tool to law enforcement and the protections to innocent owners. I'll stand for questions at the appropriate time.
Thank you. Chief Atterbury?
Hello, I'm back and I'm representing the Kansas Association of Chiefs of Police. So much has been said. Some of the things I wanted to make clear is, and because it's been used a few times, asset forfeiture funds and budgets, they're completely separate. I don't get a budget for asset forfeiture. It might be zero. You know, in my situation, I've had $3,800 in my fund for at least the last 3 years that we've put it into the repository. We haven't spent it yet. At some point we will on one of the things that's allowed through the current statute. The other thing I wanted to speak to was the incentive to go out and make seizures. That's not our incentive. Our incentive is to go out and fight crime. Sometimes seizures happen because we're out enforcing the law, finding people who are violating the law, and we have an opportunity to use state statute to impact that criminal's behavior and seize their property, that those proceeds that they have gotten through illegal means. And that's what this is for. Whether it's $100,000 or $2,000, we should be able to do that in the same civil process and not change law here in the state of Kansas so that we have criminal law for seizures and civil law for seizures. We need to have the same for both. It makes sense. It's rational. It's logical to have both. We shouldn't change because that's what some other state did. We need to do it because it's good for the citizens of the state of Kansas. And right now, I agree with another speaker. We didn't hear anything from anybody about how the current act is not working. We just heard about how they want to change it to keep us from seizing in the way we have done in the past, how we treat asset forfeiture in the future compared to how we've done it in the past. We have 3 years of data. To my knowledge, we haven't had any examination of that data. And until then, I really don't see why we would move forward with a bill such as this when we have something available to us to research and look at. Thank you.
Thank you. John, I have you down as written. Is that correct? Okay. Committee, we have written testimony opponent testimony from the KBI, from the League, and from the Kansas County District Attorneys Association. Anyone else as an opponent? Any questions of the opponents committee? Representative Humphreys?
I'll make it quick.
You're fine. I have 30 minutes to get where I'm headed, right across the street.
Okay.
Take your time.
So I've thought about, should I say something? Should I not? I thought, well, I'll say something if we work the bill, but I feel like that's not really fair because I need to say what I want to say so that Mr. Klump can respond because it has to do with something you said. So I do probably have a question if you want to come up, but while you're coming up, I will say my issue is not with the seizure. It's with the forfeiture. It's that someone's property is forfeited when there is no, when they haven't been convicted of anything. I hope you can use seizure as a law fighting tool. That's what we want to happen. It's the forfeiture piece that I have a problem with. But then the other thing is, I'll just say, my issue was you don't want to use taxpayers' dollars to investigate other crimes. But it's okay to use an innocent person's dollars to investigate another crime when they haven't been charged with something because they're innocent until proven guilty. And then the other thing that I will just say is a couple times on your other testimony, you mentioned, I wrote down the words, but I'm not gonna be able to find it in the right page. Something like this money is used in a drug crime. Well, it's not a drug crime yet. And or you also said something about the person being hang Hang on just one second, because I really hate to say you said something when I don't have it in front of me. Oh, sorry, I'm not gonna be able to find it. I kept it, well, this asset was seized in committing a crime. You use that phrase. Well, it's not a crime yet, you know, and it could be seized in a alleged crime, a potential crime. So that's the problem I have, is that, you know, already we're thinking these people are, you know, engaged in illegal activity when we seize their property. And I don't have an issue with seizing property, but I do have an issue if we already think that they're engaging in illegal activity and then we forfeit their property when there's no conviction. So I don't know if there's a question there, but I felt like I can't not say that while you have a chance to respond, because I would say that when we work the bill.
I appreciate the opportunity to respond to that. First of all, you know, one of the big philosophical differences that gets us here is, should there be a criminal conviction to seize what we're seizing in a forfeiture case, okay? Or should there not? Should it be a civil process? Kansas, along most other states, elected the civil process, and the federal government did too. The difference is not, there's so many things you said, I'm rattling my head right now. So you know, the difference here is that, or the point to be made, is that what we seize, we cannot seize just because we think a crime was being committed, although that's what one of the proponents said on one of the bills. We have to be willing to prove that it is assets of the crime. It was used in a crime to conduct the crime, or it is proceeds from that crime. Now, you said something that really bothers me, and that is the crime hadn't been committed yet. So that sounds like a crime doesn't get committed until we convict somebody. Well, the crime happened when the crime happened. If we find that bag of money and dope and all that together in a car, there has been a crime occur. We may not be able to say which person committed that crime, but we know there's a crime occurred because, one, there's illegal drugs there. Two, that money is in there with the illegal drugs. The scales and the packaging all leads to it's being distributed. So a crime has occurred at that point. The same as if tonight at the bar, Joe shoots Ted and kills him, that crime has been committed. That's a murder, and it's been committed. There's no question there is a crime, but we haven't convicted anybody yet.
I could just respond quickly. And that's not, and I did open myself up to that, and I'm fine with that. My situation is, what I'm thinking of is when there's the money and there's no illegal drugs, there's nothing else. And there we don't know. And so that's, you know, those are the cases that I've heard about.
We have no authority to seize money because we find it if we cannot tie it to criminal activity.
Crime, but we don't. But it happens. We know that.
Well, I don't know. If there was a particular case, we could look at it and see if that happened or not. But if that did happen, I can tell you the court would order us to return it. They wouldn't let us keep it. And probably it's going to get returned very quickly, because probably the district attorney is going to tell us, wait a minute, you don't have anything here to tie this to a crime, give it back to them. And that's going to happen before we even go to court. So I don't know if, you know, we had 2% of the money returned according to some of the testimony. And so why was that 2% returned? I don't know. But it would show up there if it was being done in large numbers. I mean, people all the time say, I didn't do this. No, that's not, you know, but I don't know. But without knowing the facts of each case, you don't know if that's accurate or not. You don't know what evidence was there at the time. Yeah.
Any other questions for opponents? Representative Curtis.
Ed, if you don't mind. So I just want to say I agree with much of what Representative Humphreys, and those are some of my hesitations and concerns too. Because when we heard this before we started the data collection, we had heard of some of those horror stories of somebody just walking down the street and, property being seized off of them because they had a joint in one pocket and $100 in the other pocket or whatever. But my question to you is, now with the data collection, do you think that has helped? Like, because that has to be reported, correct? So
Right.
Is that helping with maybe those that may have stretched it? And
Well, first of all, I've heard those tales of, but again, we can't seize money from somebody who's just walking down the street and got money in their pocket. There has to be some connection to a crime, or we don't have the right to take it. And if that were to occur, the first check and balance on that is probably my chief, who's going to go ballistic. Second is going to be the district attorney. And third is, if it gets to the court's going to tell you, you don't even have a case here, you got to give it back. And I just don't see how that would happen. And your second question, or second part of that, has collecting the data changed our behavior? I don't think so. I haven't seen a change in behavior. I think what it does, though, is before we did not have any data to show whether stories like that were accurate or inaccurate. And I think that's where the data helps, and I think that's where the data is important. That's why our association supported that provision back in 2018 when it became law.
Representative Owens.
Thank you. May as well stay put. So I don't know that we got to the heart of what Representative Humphreys asked, and that wasn't the seizure. Seems like all we want to talk about here is the seizure. What about the forfeiture? Why the hesitation to forfeit it before conviction? Why not wait until conviction? That's the basic fundamental question.
In those cases where we have a person we charge, I don't think that's a problem. The problem is in those cases, like I described, where you have things that you can clearly show are fruits of a crime, but we have no one we can charge. We don't have that probable cause built yet to charge, and may never have. That we don't want to just let those fruits of the crime go to the criminal. I mean, that was the essence of civil forfeiture, is you take away the profit of committing crime. And that's why the law is written, no crime, you can't seize it.
So would you be opposed then if there is a criminal complaint filed and there is an individual charged, waiting on those assets until after conviction?
Yeah,
I mean, maybe I'm splitting hairs here, but it seems like that's the crux.
Well, I can tell you this. Are we in any hurry to get our hands on the cash and be able to spend it? No.
Okay.
No, I mean, that's probably the simplest way to answer that. But again, there's a lot of reasons that you may not reach conviction in a criminal case, but there's still very strong, clear evidence, probably even in most cases beyond a reasonable doubt, that forfeited or that seized item or value, money, whatever, is fruits of a crime.
And maybe that's what needs parsed out a little bit more. But thank you.
I think those are good details. That is why this whole thing needs a lot more study.
Yeah. Thank you.
Representative Wheeler.
Thank you, Mr. Chair. I have a question of Ms. Washburn, please. Ms. Washburn, I have no idea what my question is. Do you have an answer?
I would really like to talk about a few things if I could. Thank you so much, Representative Wheeler. I've known Representative Wheeler since he was the county attorney in Finney County, and I was appointed defense counsel out there. To answer some of the concerns I think that have been raised, number one, we don't have a problem waiting until there's a criminal conviction. If there is a companion criminal case, what normally happens, again, provided for in the Civil Asset Forfeiture Act, is we pause the civil forfeiture. And the concern is we don't want to require in a civil case this individual incriminate themselves. So there's a provision in the Kansas Standard Asset Seizure and Forfeiture Act that allows you to pause the Civil Forfeiture Act until the criminal case is resolved. And what I will tell you also is if it is resolved in favor of the defendant through perhaps a motion to suppress, that does affect the civil case as well. Can I finish one more thing? Okay. Now, we have to meet a legal standard in order to seize as well as to forfeit, and they're two separate legal standards. There is no evidence that I'm aware of showing that we seize things without meeting that legal standard, because we are required to, much as you are in order to file a criminal complaint, required to file an affidavit sworn to by a law enforcement officer stating there's probable cause. So we are required to show the court, play show and tell with the court, and show them exactly what evidence we have tying that property to a criminal act. Thank you very much, Representative Wheeler.
Representative Owens.
Just back to that shall pause, may pause, can pause. Who decides that and when?
The statute actually says that it can be done at the request of the claimant, or it can be done at the request of the prosecuting entity, or essentially the law enforcement agency's attorney, which is usually me. I think my practice has always been, if there is a corresponding criminal case and the forfeiture has resulted from that, I always make the request. That's my pattern in practice, but either side can request it.
I wonder if maybe there's some solution in there that's a mandatory, that it shall be paused if there is a companion criminal. I don't know.
I'm not recalling the language exactly. It may be a shall, but I do recall that it is permissive at the very least. So it goes back to my original point. It's all there. It really is. I'm happy to answer any other questions I can, considering I kind of do this more often than I'd like.
Any other questions for the opponents? Hopefully not online because I've shut my computer off. So.
I'd like to go home to my puppy.
Okay, committee. I'm closing the hearing on House Bill 2640. We're not going to work any bills today, but here is the list for tomorrow. So the first four are the same. I thought we'd work today, 2652. And then the three expungement bills, 2556, 2557, and 2575. And then to add to the list of possibilities, there's still some amendments possibly out there. So we'll see 2364, 2608, and 2495. And hold on one second, because when Natalie gives me a strange look, I just want to confirm I haven't said something I shouldn't. She says I'm good. Okay, we're adjourned. Thank you.